panelists. I'm Michael Dell'Angelo. I'm an executive shareholder at Berger, Montague in Philadelphia in the United States. We're a plaintiffs-oriented class action firm. My practice is more or less evenly split between securities and antitrust litigation. Our panel is very cognizant that we are the last impediment between everyone here and the drinks hour. So our objective is to make this lively, and I am somewhat consoled by the fact that if we fail in that, the drinks will probably be better than they would have otherwise been. So with that, let me introduce who we have on the stage. The far end is Hal Singer. Hal is a director at Econ 1 and an adjunct professor at Georgetown. Next to Hal is Bob Boone, a partner at Bryan, who runs the class action practice on the defense side there in the Los Angeles office. And remotely on the screen behind me here is Dante Quaglione. He's a director at the London office of the Berkeley Research Group. Maybe if each of our panelists want to just take a minute to introduce themselves a little more fully, and then we can get started.
Me first? All right. Well, I guess you guys know that I'm a managing director at Econ 1, and I teach at Georgetown. I teach pricing to MBA candidates. With respect to class experience, it's hard to say this and not sound like I'm boasting, but I've had 7 antitrust classes certified around my impact models, and 1 consumer protection class certified around an impact model. That was the MacBook keyboard defect case. And I guess the last thing I wanted to say is that there's some current cases that I'm working on, some of which I can't disclose, but the ones that I can include the UFC monopsony case, INRI foreign exchange antitrust, INRI capacitors antitrust, and the Juul Labs marketing and sales practices case, which is a consumer protection case.
Good afternoon, everybody. I'm Bob Boone, again from Bryan, Leighton, Paisner in our Los Angeles office. And I have handled hundreds of class and mass actions around the United States in state and federal courts, and principally in the areas defending financial institutions, manufacturers, and food companies.
Dante?
Hello, everybody. My name is Dante Quaglione. I'm a managing director in the London office of Berkeley Research Group, PhD economist, and economics as a background. A good chunk of my practice comes from, litigation, damages, competition damages, and class actions. And I'm currently working on class cases that I cannot disclose. That being said, I wanted to apologize for not being able to be there in person, as the pandemic has not really made my life as easy as I would have hoped. That being said, back to you, Mike.
Sure. So since our panel today is conditions for class certification, and we find ourselves in the UK, what we would like to do is talk a little bit about the conditions for class certification under MERICS, and try to approach some of the emerging trends or hot topics in certification in the US, and think about them through the lens of what MERICS is teaching us and where we see the UK going. So as I'm sure many or all of you know, in 1966, with the enactment of Federal Rule of Civil Procedure 23 in the United States, the US regime kicked off class certification as a procedural device in litigation. A collective action regime was implemented in the UK in 2015 through the Consumer Rights Act, and that was extended at least to competition claims. And as what we've seen with the relatively recent decision in MERICS, and I know we were fortunate enough to have Mr. MERICS with us here today, it paved the way for collective actions, at least in the competition space in the UK. And one of the things that the MERICS decision did is it provided a framework for where the UK is going, or appears to be going, in terms of those collective actions, kind of against the backdrop of this very well-developed but different body of law in the United States. MERICS appears, at present to be somewhat less complex, but there are a few more recent decisions that we'll talk about at the end of our time today, and in the interim, try to weave in some of what we've seen in the emerging topics in the US and what's happening in the UK. And so with that, I'd like to turn it over to Bob to just give us some background on the MERICS certification or collective action standards as kind of a jumping off point for our discussion today.
So I think as everybody, at least who practices here in the UK knows, in a collective action under the Competition Act, the plaintiff has to apply for a collective proceedings order, or CPO, they apply to that to the CAT. And there are two conditions that need to be met: authorization condition and eligibility condition. And the authorization condition is approval of the person seeking to represent what we call in the United States the putative class. The representative does not have to be a class member. The CAT must determine essentially, is it just and reasonable for that person to represent the class? And the CAT will look at several things. Will the representative fairly and adequately act in the interests of the class members? Can they manage the proceedings? Do they have a reasonable plan for prosecuting the claims, notifying the class members, arranging for expenses that will be incurred in prosecuting the claim? The CAT also look at whether there's a material conflict of interest between the members of the class and the representative in relation to the common issues that are presented by the claims. And is the representative able to pay the defendant's recoverable costs if the claim fails under the loser pay system? For the eligibility condition, the court is determining whether the claims are eligible for inclusion in collective proceedings. And that essentially is that the claims must arise from the same similar related issues of fact or law and are suitable to be brought in collective proceedings. This is also known as the commonality, commonality or common issues. There needs to be an identifiable class of persons. In determining suitability, the court will consider a number of things: is class treatment an appropriate means for the fair and efficient resolution of the common issues? It'll do a cost-benefit analysis of treating the case as a class. It'll look into whether there are other lawsuits asserting the same claims on behalf of class members. It'll look at the size and nature of the class. It'll also look at, can one determine if any person is or is not a class member, and address whether the claims are suitable for an aggregate award of damages, which is the type of award that can be had under the Competition Act. And then it'll also look at, are there other means of resolving the dispute that are more efficient than what's being proposed? So those are the conditions for certification, for getting a CPO. I will note, because we'll touch upon this a little bit later, the one big difference, I think at least, between the UK system and the US system is that here the predominance of individualized issues over common issues is not really a factor here, whereas in the US, at least in damages, class actions, it is a factor for the court to consider, and quite often that is the battlefront at the certification stage, and why many courts will not certify claims under the US system.
Okay. So Dante, as somebody who's been on the forefront on the UK side as an economist, can you share some insights on what you see as kind of the emergence or the trends following the MERICS decision to where we are today?
Yes, I think there are four aspects of the rulings that are of particular interest for experts like me. I mean, the basic one is suitability, which is, of course, to be decided based on the advantage of bringing class, so a class claim as opposed to individual claim. And this means that, of course, we'll need to deal with a bunch of class members instead of just individuals. The other important ruling is that aggregate damage is really one of the conditions, or one of the factors to be considered in assessing or certifying a class, not really a strict requirement. So that kind of valuation has to be done from a broader perspective, not on a very singular and specific one. As with other practices in the litigation, in UK litigation, broad acts and informed guesswork is perfectly acceptable and should not really hinder class certification. That would be the third ruling of interest. And very importantly, the methodology for distributing aggregate damage to class individuals is not something that has to obey the compensatory principle or individual laws. So these are aspects which are certainly made, rulings by the Supreme Court, of course, in the Merrick's case, that have certainly made class certification easier. Now, as far as trends are concerned, I basically see two things happening very clearly. One is that defendants may really change their litigation strategy and decide to narrow the scope of the claim by just defining or smaller classes instead of just seeking dismissal or pushing for opt-in kind of claims. And the expert job, which is what, of course, attaches me directly, I think are become much less uncertain as far as our duties really to prove impact of any misconduct. So these are, I think, the two most immediate consequences which will be triggering trends for the future.
So, Hal, we haven't had a chance to hear from you yet. Any insights from your perspective on what you think the UK may need?
What it needs? I think they need a charming economic expert. I'm just.
Are you
we worked on that
for
one
yourself?
last night, but I don't know if I have any advice on what they need. I'll just talk about what goes on in the U.S.
Okay. All right. Well, then let's shift to what goes on in the U.S. and talk about the general scope of certification standards. Let me turn to you, Bob and Hal. I think it's fair to say, kind of building off of something that Dante just said about responding in terms of how the claims change. I think likewise the defense side has responded to the evolution of claims in terms of how it challenges them. And one thing that we've seen emerge in the United States in certification is certification went from a decade, maybe 15 years ago, to being a relatively straightforward process that was almost rote to some extent, to now living in a world where certification battles are often a series of mini trials with live witnesses taking days, sometimes as much as a week. And I'm wondering if, Hal, you could maybe start us off, and then Bob, with some perspective on what you've seen about some of the recent evolution in class certification from your perspective.
Yeah, sure. And so at a very high level, I'll just say that the standards that prevailed just a decade ago were much lighter, looser than the standards today. And I'm old enough, sadly, to have watched these things evolve. But back in the old days, we needed to basically show two things. We needed to show a common method for proving impact, which was typically turned on a two-part proof. That there's inflation in the average price that class members pay, and then some kind of pricing structure that would allow the economist to say that to the extent everyone is connected to the average, inflation, the average would touch all class members. Defendants have succeeded in convincing courts in the interim decade that there's something wrong with averages, despite the central importance of averages in statistical analysis. And so to this challenge, the plaintiffs' experts have devised increasingly complex ways to get around this attack on the averages. And some of those, and I'll go into maybe detail later, is being able to, for example, allow for the effect of the conduct to vary by class member. That's one approach. Another approach is try to predict what each individual class member would have paid in the but-for world. But the bottom line is that this old two-part proof is becoming increasingly difficult to succeed on. I maybe just with another second, I'd say that there's been two other developments. One from this case called Berger v. Comcast, which I was involved in as well. And here the plaintiffs were faulted, or the plaintiff's economic expert was faulted for not being able to decompose damages across the disparate restraints that were at issue. And so as a result, it has caused plaintiffs to reconsider how they're going to approach what are called monopoly broth cases, where you're asserting a whole slew of restraints that allegedly are in violation of the law. And we've come up with certain solutions, again, increasingly complicated, to get around that hurdle as well. And maybe when we talk about the UFC case that Michael and I were involved in, we can talk about how we handled the Comcast problem. The final thing that I want to talk about that's making the standards increasingly harder for classes to be certified in the US is the American Express decision. Now, that wasn't a class cert decision per se, but because these class cert hearings are effectively mini trials on the merits, if you have to do a new standard at the merits, then you're going to have to do it at the class certification stage as well. And so there were two new hurdles that the Supreme Court threw up for plaintiffs. I know I'm making this sound very dreary, but the first was
but it is if you're on the plaintiff side.
That's why I don't have any hair anymore. Neither does Michael. Bob, on the other hand,
Bob has all the hair.
So the first thing is that for vertical cases, plaintiffs can no longer rely on what was called direct proof of market power. We instead have to define a relevant market, which is a very defendant-friendly exercise. It's purely academic and hypothetical, and I could go on, but that it certainly plays to the defendant's interests. And the second wrinkle that came out of American Express is that they said it was not enough for plaintiffs to connect the restraint to harm on one side of the market whenever you're dealing with a two-sided platform. So now every defendant tries to characterize itself as a two-sided platform. I mean, I think Bob and I might even be two-sided platforms under some of these arguments. And so, again, this plays the defendant's interest because it is very hard to trace out the effect of a restraint on both sides of the market and show that there's effectively a net price increase. And maybe I'll stop there. I don't want to be too gloomy, but these are some of the new obstacles that we're having to deal with.
So the class certification process these days in the U.S. is, as Mike and Hal both mentioned, is much more involved than it was 10, 20 years ago. And there are a number of different factors under Federal Rule 23 or state law. And the courts, what you see today is that the courts really dig into those issues. The judge wants to know, what is trial going to look like if I certify this case? And in the U.S., we take discovery, extensive discovery, before the certification stage. There are often multiple experts on both sides. There are often non-expert testimony, particularly if a defendant wants to put on some anecdotal evidence to try to bust up the certification, to show differentiation between the class members, or establish that they're not common issues, or that the individualized issues predominate. So there's a huge amount of resources that go into the class certification stage, and the use of experts and the sophistication of the experts that are now being used, and under some U.S. Supreme Court decisions that have come down in the last decade about the rigor that judges are supposed to use to determine whether it's appropriate, the case is appropriate for class treatment, that you get these lengthy briefings and hearings, and that's become the battleground really for class actions in the U.S., because oftentimes the potential risk to a defendant, if a class is certified, means that the case is never going to go to trial. It'll end up settling after certification, and oftentimes you see it settling even before certification because they don't want to take that risk. So it is a very in-depth process, much more involved than the process at this point in the UK.
Yeah. So Dante, let me put it back to you. We've heard a little bit about the evolution of the standard in the US and how difficult things have become there and frankly complex. And where you gave a nice summation about kind of where we started with Merrick's and how that's evolved in the relatively short time since that decision. Can you, kind of on the background of what Hal and Bob have had to share, give us some perspective on what you see some of the challenges maybe coming down the line for UK practitioners and maybe what they might learn from what we've heard about what's happening in the US?
Sure. Really, I think for the time being, the most important difference relies on the nature of the, let's say, the arguments that have to be set forth by experts. I mean, a class action case in the UK sounds and looks a bit more qualitative than quantitative for the time being. Although the implications of the Merrick's judgment make me think and believe that things will change shortly, because since the Merrick's judgment made really class certification easier and eliminated a number of complexities that otherwise experts would have, required to cope with. Chances are that this will open, and I think it will open, the possibility to use some quantitative approaches, certainly in the future. I mean, the reality is that this is all depending on how and how quickly, first of all, and then in what direction really the practice will develop in the UK. Considering the class certification is going to be easier than the pre-Merrick's, let's say, regime, I would expect that, more cases will be filed, and therefore the practice will have the chance to develop more quickly. And I anticipate an increasing relevance of quantitative tools as opposed to just the qualitative arguments, which was what initially seemed to be the case.
Thank you, Dante. So one of the things that Bob mentioned earlier in his discussion about the standards was made reference to the concept of commonality, which has really become kind of a hot button issue in the United States and is consuming a lot of time, both the lawyers and the experts at certification. So Bob, could you maybe start us off with just a little précis about what commonality is, and we can kind of dig down a little bit about what we're seeing in the US and the UK?
Sure. And I think you've seen it in the recent, in the Merrick's decision and the recent decisions over the last month here in the UK. I mean, commonality really is, it's determined by how the plaintiff frames their case. And from a defense standpoint, the more simple the plaintiff frames their claim, the harder it is to argue that they're not common issues. And the whole goal is to be able to, at least in the US, is with your named plaintiff and this common evidence, if you prove that the common evidence is going to prove the named plaintiff's case, but it also proves the class member's case as well. So, like I said, it all really depends upon how the claim and the issues are framed. The more complex factually a case is framed, the more difficult I think it's going to be for the court to identify common issues. So from plaintiff's perspective, I know I'm stepping out of my shoes here, I think the goal is to keep it simple. For defendants, you want to identify such things as variations in data that is being used by the plaintiffs. If the alleged practice or conduct is conduct that's not, let's say, not automated, but depends on human conduct, particularly discretionary conduct, that can be used to argue that they're not common issues. And of course, a defendant always wants to try to argue that they're not common issues based upon certain defenses that they may have to the claims. Some courts will just say, well, that doesn't really mean that they're not common issues. It goes to the issue of predominance, but I've had success arguing that it shows a lack of commonality. And again, if there is a human factor present that needs to be analyzed for, let's say, a waiver or estoppel or consent defense to a claim, that can be used to attack commonality.
So from the plaintiff's perspective, I generally agree with Bob that simpler is better. But the one observation I can offer is that no matter how simple we try to make it, it ends up being complicated. And where a lot of the real heavy lifting falls on establishing commonality are people like Dante and Hal. And I think it's fair to say, Dante and Hal, that commonality really has become kind of a central issue of what both of you are doing. So Hal, I was wondering if you could just address from your perspective, how you're currently dealing with some of the challenges presented by commonality at the certification stage and what you're doing to meet the test as it is.
Sure, and so I gave a taste earlier, and then I'll try to descend the abstraction ladder a bit by talking about two cases in which the class was certified around models that I offered. But in broad strokes, what we're trying to do, of course, is establish a causal nexus between the restraint at issue and a measure of welfare of the consumer. If it's a monopoly case, we're looking at prices. If it's a monopsony case, we're looking at wages. And first case I want to tell you about quickly is this case called In Re Leiterderm Antitrust. It was a Payfordelay case, and I was the expert for the indirects. And in that case, we had to first establish inflation in the price that is paid by the directs, and that's the WAC price, the wholesale acquisition price. And we did that by relying on the defendant's own internal modeling of what the prices would have looked like absent their payment to a generic not to enter the market. And so that was called the forecasting method. And so that was kind of step one. First, we had to establish that the WAC price was inflated by the payment not to compete. But then we had to connect, the WAC price to the independent, to what the indirects paid. And to do that, we had the benefit of having every payment ever made or brokered by the largest PBM in the country. It's OptumRx, and it turned out to be a very nice data set because one, it allowed us to make that mapping for how do WAC changes influence changes of what ultimate end payers are paying for drug prices. But also, if we could establish that every end client of OptumRx was injured, because OptumRx offers the largest rebates in the industry, it followed that indirects of every PBM was injured as well. And so that was how we established impact in that case. And then quickly, I'll move over to another kind of more garden variety price fixing case. This was In Re Capacitors antitrust, and it concerned an alleged conspiracy among Japanese manufacturers of capacitors. And in that case, there were two experts, Jim McClave and myself, who put forward an impact model that showed not only was the average capacitor price inflated as a result of the conduct controlling for everything else that you could imagine affecting capacitors, but then we went and predicted what each class member would have paid absent the challenge conduct. We compared that prediction to what the class member paid in the actual world. And we showed something like something in the high 90% of class members overpaid through that model. And some of the variations that I put on the model was to show, for example, that when you allow the conduct to vary by each defendant, that every defendant's unique conduct parameter was statistically significant and positive. We also did it for different capacitor types, but the judge was sufficient. Well, he thought we had done enough to satisfy that standard, so it allowed us to get to a jury trial, and that trial started in March of 2020, which you may remember coincided with COVID, so we had to call it off and it's starting back up again in the winter of this year.
Right. Well, good luck. So Dante, obviously, as I said, commonality I think is really central to what you do, even though the standards differ somewhat in the UK. Could you maybe share some perspective from the UK side on what you've heard about Hal and how he's dealing with it, and maybe where you see things going in the UK?
Yes. Well, I think an important difference between the UK system and the US system, at least for the time being, is that in the UK, commonalities really boils down really to choosing a compelling narrative. So it's qualitative, as I said before. At the same time, I envisage a trend whereby, or I anticipate that things will get more quantitative in the short term, even because basically, what does it mean, compelling narrative? I mean, we just, claimants need just to determine how, conceptually, I mean, not through numbers or statistical evidence, a certain misconduct has caused harm to the class. And then, of course, this is also what drives the choice of any empirical tool that will be used when damages quantification is relevant. In the US, the approach of commonality is very formulaic. So it's quantitative and has, to obey very specific requirements. In the UK, this is not the case. But I think we will move in the same direction, simply because, when you develop compelling narratives, you are basically developing a qualitative argument, which can be rebutted by another qualitative argument. And of course, even though very strong as arguments, chances are that adding empirical evidence or some kind of quantitative exercise or the rigor of statistical modeling, for instance, which is one how things can be done, of course, adds to the strength of the position and the arguments themselves. So I anticipate that the practice in the UK will develop closer to the one that is in place in the US. I'm not saying that it will become exactly the same approach. Chances are that, of course, the approach, although quantitative, will be different. And of course, it's early to say, but that's what I envisage.
So thanks, Dante. Something you said kind of caught my ear. You said at least at present, the standard in the the UK is more qualitative. Could you maybe just add a little context around that? Maybe describe for folks what that means at present, and a little bit about how you go about meeting that more presently qualitative standard?
Yes, I think a good example comes from the Supreme Court judgment, Google versus Lloyd. I mean, basically the Supreme Court determines that in making the case, claimants would need to they cannot just presume that there is a wrongful conduct and then there is damages associated to that conduct. It's really the Supreme Court required and determined that the claimants will need to prove that defendants made wrongful use of personal data. Of course, we're talking about a data breach case. For the individual that are part of the class. And then the second requirement is that the claimants will need to establish some sort of a causality link between the data breach and the arising material damage or distress for the individual part of the class. So these indications clearly refer to the development of a narrative rather than empirical evidence, documented through statistical modeling. So that's why I got my impression reinforced about the relevance of a more qualitative argument as opposed to quantitative one. But again, things are expected to change, at least in my humble opinion.
Okay. Thank you, Dante. So in a moment, I'd like to jump ahead to some of our more substantive areas. But before I do that, Bob, just any final thoughts on maybe where you see all that going with respect to the kind of areas around certification, maybe just dispute resolution generally. We heard a little bit this morning, I think Gordon Cooney during his panel mentioned the emergence or repair by plaintiffs to mass arbitrations. Anything you're seeing along those lines or can predict for us?
Well, I guess I have a couple thoughts. One is I do think the court's analysis at the certification stage here in the UK and in other jurisdictions where it's in early development will become more rigorous. I think that's just the natural evolution as you build a body of case law around a class action scheme, regime. That's what's going to happen because litigants are going to attempt to distinguish or analogize their case to prior cases, and that requires a little more factual analysis comparison by the litigants and the court. So that just requires the court to dig in a little bit more. It also provides more predictability in analyzing risk with new cases. If you have a body of case law where you've had some claims that have been certified, it might prompt those to settle quicker. So that would involve more arbitration, mediation services.
So in the last 10 or so minutes that we have, which if everybody agrees, we could happily extend to another hour or so if you guys would just be willing to wait on having drinks. Just if you want to maybe take an informal poll, Rachel, you let us know and we'll just keep going. But depending on the outcome of that, in the last 10 minutes or so that we have, since we have two, really leading economic experts here, one from the US and one from the UK, I wanted to just ask you both briefly to kind of set the table for what type of information is important to you in the certification process with respect to the relative set of standards that you both look to, so that maybe we can use that as a segue to talk about the last two kind of substantive areas we wanted to touch on, which is just labor economics and monopsony, because they're really two emerging trends in the US, and I think we may find, gain some purchase in the UK as well. So whomever wants to jump that, you want to start us off, Hal?
Well, sure. I've had, I actually started my class cert career, now that I'm thinking about it, on a labor case. It was the Arizona travel nurses case, but that was back in 2008-ish when the standards were at a different level. But more recently, I was the expert in the UFC monopsony case, as well as the expert in some no-poach cases. And so just quickly, I can tell you what happened in those cases. And Michael, as I noted, was there and came with me to Las Vegas and suffered through the Golden Nugget, which I would never suggest anyone ever stay in, but it is close to the courthouse, but still it's worth getting in a cab to avoid that place. Hold on, I digress. UFC, there were 6 economists in all in that one, and I was kind of the generalist antitrust economist. There was a dedicated labor economist on both sides, and there was a sports economist on both sides. So, and there was a six economist hearing that was set over a series of days. And the model that I put forward was to show that UFC managed to suppress the wage share paid to fighters who were exclusive to the UFC over the course of the class period. In very broad strokes, the UFC was able to push the wage share. I realize I'm speaking Greek, but that's just what share of the purse or pot of money that an event threw off were down to the fighters themselves. The UFC was able to push that from about 29% at the beginning of the class period to about 19%. And so in my regression model, I was able to, I tried to model what each fighter in a given fight was paid as measured by his or her wage share as a function of a whole bunch of variables, whether they won the fight, how many punches were thrown, yada yada, their ranking, and then finally, like how many fighters in the relevant input market were foreclosed by virtue of these long-term exclusive contracts by the UFC. UFC makes it impossible if they want to keep you to break out of the contract, and the rivals, knowing that, don't make much of an effort in going after the inputs, and that's what causes the wages to stagnate. And so the big fight in that case was whether my use of wage share, this is all new because we're really on the frontier now of antitrust work in the monopsony space, whether I had invented a lens of analysis and whether I should have instead have used wages as the dependent variable. And I, over a cocktail, we'll get into how I won that one. But the good news is that the judge announced in December of 2020 that he's certifying the class. The bad news is that he has yet to issue the opinion. So this is causing me moderate stress and only 1 day of therapy per week. The no-poach cases by contract are causing me high levels of anxiety and probably 3 or 4 sessions per week. But here, the judge in the McDonald's case, and I have to tread lightly because it's still alive, decided that because, and I'll make this quick, Michael, the independent franchisees, of course, were barred from poaching or hiring a worker from a rival another neighboring independent franchisee, right? Now, they didn't enter into contracts by themselves. Each one signed their own contract with the mothership, McDonald's. But in that contract, they waived their ability to go out and compete for labor, right? And the judge said that because they did, and I'm paraphrasing, I'm doing this with a ton of respect and lovingly, but he said that because they didn't enter into individual contracts with themselves, that is, the franchisees didn't enter into contracts, but instead with the mothership, that this arrangement is best understood as being a vertical one, not a horizontal. Never mind the fact that these franchisees were horizontal competitors in the market for labor. He said that because it's vertical, and because American Express dictates how we should study vertical cases, we have to proceed via indirect analysis of McDonald's market power. And there's no way that these guys could possibly have a high share in any relevant market because you've got McDonald's and Burger King and Kentucky Fried Chicken and all these other wonderful quick service restaurants. So he wasn't even interested. He didn't even cite to my regression analysis, which showed that when the no poach came off by virtue of a settlement with the Washington State Attorney General, the wages for McDonald's workers suddenly and unexpectedly spiked in September of 2018, controlling for all other things that would influence the level of wages. But I couldn't get the judge to look at that because that was direct evidence of their power, and by American Express, in his mind, direct evidence is now off the table. So I'm doing okay, and in case anyone was worried, but that case is still alive, and so that's all I'll say about that.
So I think, Dante, it's fair to say we're seeing some similar things in the UK around labor competition and no poach agreements. Can you just offer briefly some insights or challenges that you're seeing, maybe benefits from collective actions in the labor market area, or yeah?
Absolutely. I have to say that the practice in the UK is relatively at an embryonic stage compared to the US one, but still, I think there are two challenges and two benefits that I see. The first challenge is that, unlike most of the competition analysis that are carried out, for labor markets and illegal agreements and no poaching agreements, there is also a very strong dynamic implication. When I say dynamic implication, I mean what are the repercussions for firms that are involved in these kind of practices in the longer term. So, for instance, if we look at things by just investigating the static perspective, of course, no poaching is going to be beneficial for economic efficiency because it removes the obstacle for individuals and workers to move across jobs. This, of course, it enhances the ability of job seekers to find the right job and reduces the time they are between jobs, improve their matching with the openings, etc., etc. However, if you look at the dynamic side of things, oftentimes it's been argued that to the extent that it's more difficult for firms to protect, the retaining of the workers they hire, they are going to be more reluctant to invest in training and in train their resources, knowing that, of course, if they train a resource, the resource may leave to another company, maybe benefit somebody else, possibly a competitor, and their training investment is going to be stranded. So this, of course, will be a poor outcome if you look at the dynamics of things. At the same time, of course, it's going to be a better matching between demand and supply skill, which may have a positive effect. So the net effect between these two, it's an empirical question, it depends. But certainly the dynamic aspect is an important aspect to consider. Okay. The second challenge is a bit more, if you wish, methodological. I mean, traditional toolkit that we have or learn from microeconomic textbooks is way insufficient to grapple with the main challenges of a complex labor market, because basically all the models we have in micro textbooks are frictionless. So we assume that price and wages can change, and demand, the supplied and quantity demanded and supplied can adjust immediately. Well, this is not the case for the labor markets, and in addition, the labor market is characterized by a certain heterogeneity of skills and worker features, etc., etc. So, fortunately, modern labor economics has devised innovative theoretical contributions, which actually happened to, the contributors happened to win the Nobel Prize a couple of years ago, so which are better able to reflect all the complexity, the frictions in the markets, and the heterogeneity. So this, I think, is going to be good for us economists that need to develop economic analysis also for class action cases. Talking about the benefits, I see two benefits. The first is that, in my humble opinion, the medic's judgment really appears to be conducive of the application of these new tools. So it will be something that facilitates the deployment of these new tools of analysis to better capture really the common impact on the class. And second, of course, the good thing about class action on labor issues is that most probably each individual by himself will not be really able to seek any any of his harm redressed if he had to really go to courts on an individual basis.
Thank you, Dante. And then just in the couple minutes that we have left, that labor piece ties nicely into this concept of monopsony, just a competition issue where you have one buyer in the market. And some of you may have seen very recently, last few weeks, the DOJ, Department of Justice in the U.S., challenged the proposed acquisition by Penguin of Simon & Schuster. And one of the things that the DOJ said is that the acquisition would, quote, result in fewer authors being able to make a living from writing and fewer and less diverse books being published. And that's notable from, I think, the perspective of those of us doing class actions and competition-related claims, because it suggests that there's this shift toward kind of the buyer side of the market and input markets generally, which exist in abundance on both sides of the pond. And I want to just jump ahead to Bob for a moment here. As somebody who spends the majority of their time on the defense side, it seems to me that this shift could be really significant for business. And wondering if you could share your perspective on what that shift may mean in terms of how you're counseling your clients, what challenges it presents for them through certification, anything that you're willing or comfortable to share in terms of how it ties into the certification fights that may lie ahead.
Sure. Well, I'll stay general.
Yeah.
I always counsel clients who face class actions or potentially face class actions, and that's in America. That's almost every consumer-facing business, directly or indirectly, consumer-facing. So one is to have a battery of sophisticated experts that you may need to defend cases. The other thing is we as a law firm, we monitor cases, particularly novel theories, and consider the potential impact on clients. And then the other thing I always recommend to clients is to, and somebody else had a good name for it in an earlier panel, and that is horizon scanning. I mean, they know their business best, but they need to be on the lookout for potential risks. Many sophisticated clients have risk assessment groups that assess risks, and in today's climate, particularly on the consumer front, if you have a highly profitable line of business, you need to be the company needs to be taking a close look at your practices, particularly if you're in a regulated industry in the U.S., because at some point in time, it'll come under scrutiny, either by the regulators and or a creative plaintiff's lawyer out there. So that's just general advice that I always give clients on the class action front.
So like I said, I think this panel could go for another hour or so. That doesn't seem to be gaining a lot of purchase in our informal poll. So let me just take the last minute or two here. Is there something that you wanted to conclude with, or just Hal? I don't know, like you had something to say.
questions? Or are you going to allow
But
for
that's where I was headed.
Okay.
If there are any questions other than can we be done? So-
I think everybody's ready for the bar.
Yeah, okay, very good. All right, well, thank you all very much.